Lok Adalat is under challenge, and there is an objection regarding maintainability, my lord. May I
क्या
address
मतलब?
that first?
What is the objection with regard to the maintainability?
my lord, 226 मैंने पेश की है, जैसे कि maybe
The
over.
objection with regard to the maintainability of the writ petition is hereby overruled.
जी.
जी
Now
बताइए
may I come to merit of the case, my lord?
सर। वो अशोक राव वाला जजमेंट क्या है सर? उसमें क्या लिखा है कि रिट पिटीशन अंडर
My lord,
226
मैं आपका अपहोल्ड किया हुआ जगदीश साहू वर्सेस करण सिंह पे एक बार पढ़ देता हूं सर। पैरा 3 है, द सुप्रीम कोर्ट इन द केस ऑफ स्टेट ऑफ पंजाब एंड अदर वर्सेस जालौर सिंह एंड अदर्स रिपोर्टेड इन 2008 2 SCC पेज नंबर 660 has held that if any person is aggrieved by the order passed by the Lok Adalat, then the only remedy avail to him is to file a writ petition under article 226/227 of constitution.
चलो, मुझे मालूम था इसलिए मैंने आपको ऑब्जेक्शन ओवररूल करने के बाद आपसे पूछा।
Indeed, my lords, but I was also prepared.
Pardon, sir?
My lords, I was also prepared that my lord may ask the very pertinent question also, my lords, that what is the case
मैंने
law?
सिर्फ ये चेक करने के लिए पूछा था कि आपने तैयारी की कि नहीं की।
Indeed, my lords.
पहले मैंने ऑब्जेक्शन ओवररूल कर दिया क्योंकि आई न्यू द जज।
My lords.
तो सेकंड वाज द क्वेश्चन
Lordship. On merits, my lords.
Which is that order of the Lok Adalat?
P3, my lords, annexure P3.
So it was withdrawn
Ji.
by your counsel.
Yes, my lords. I did not authorize him. मैंने उसको बिल्कुल भी बात नहीं।
Have you approached the bar council?
Yes, I have.
Which is that, sir?
Lordship, that is at annexure.
Have you deposited the requisite fee? Is it the method of filing a complaint? So what is the procedure? Whether a requisite number of the copies of the complaint are to be filed along with the complaint, or ऐसा ही
My lords, he cannot.
Sir, please, sir. Sir, मुझे नहीं मालूम है, आप ही लोगों से तो पूछूंगा और किससे पूछूंगा?
जी सर.
What is the procedure for approaching the bar council?
My lords, there is a format in place to my knowledge.
Format के साथ कुछ फीस भी है?
There is some requisite fees, and on affidavit, I think he has to submit it.
तो बस सर पहले आप वो कर दीजिए, उसके बाद मैं आपको फाइल करने की लिबर्टी दे दूंगा।
Sir, he being a poor man neither can he afford it.
नहीं सर, अगर बार काउंसिल एक अधिवक्ताओं की संस्था होने पे अगर कहें कि हमें किसी की गरीबी से कोई मतलब नहीं, आपको तो फीस देनी पड़ेगी।
नहीं सर, वो बात
सुनिए, वो आपका प्रॉब्लम है। और अगर वो कहती है कि हमारे सुनो, और अगर वो कहती है कि हमारे पास फीस को वेव करने का अधिकार है, तो उस अधिकार के अनुसार आप आवेदन लगा दीजिए।
सर, he is a village person. He can hardly afford to come to jail.
वकील साहब,
जी सर।
इससे ज्यादा बॉस कुछ सुनना चाहते हैं तो तैयार हो जाइए।
My lord may give me 15 days time. I will file a proper petition.
No,
my lord, he may not afford the second petition.
His son
died. Sir, his son passed away. Sir, his son passed away. His young boy passed away, sir.
आप लोग वकील साहब, आप लोग बड़े फक्र के साथ कहते हैं कि साहब हम हर केस में फीस नहीं लेते हैं। मैं नहीं कहता साहब। सर सुनिए,
जनरलाइज सर, मैं नहीं कहता
हैं कि हम लोग
अरे सर, मैं नहीं कहता सर, मैं नहीं कहता। दिस इज प्रो बोनो सर। सर, मैं नहीं कहता।
16627
This is pro bono. His son died away.
Okay, sir. Now allow me to.
Indeed, sir.
I am dismissing the petition with liberty to file afresh after approaching the bar council in an appropriate manner, sir. 1662. This is nothing. It is an eyewash, camouflaging, और कुछ नहीं है। 1662.
That is on merit, if I may address it.
Article 226 of Constitution.
May I address it?
File. Seeking the form.
Sir, my contentions may be considered once. My lords, my contentions may be considered once.
Then I will not grant you any liberty.
Yes.
Right.
I bow down to that.
Fine.
I bow down to that.
Fine.
Once I start my arguments, my lord, there would be no turning back.
Yes, sir. I should not interfere. Yes, you are right. आपने कल का वीडियो देख लिया है सुप्रीम कोर्ट का, therefore you are also trying to step into the shoes of the same lawyer. No problem.
No, my lords, may I
No
argue my
problem,
case?
sir.
He is a
Please
very,
continue with your argument. Please continue with your argument.
my lords, his son died away, sir. And my lords, the Avedan may be seen, the withdrawal application. That is at the annexure P3, my lords. That is at annexure P3 typed copy. May I read it once, my lords? आवेदन पत्र अंतर्गत लोक अदालत में आपसी राजीनामा व प्रकरण को वापस लेने बाबत महोदय यह कि उक्त प्रकरण आवेदक गण पक्षकारों की आपसी सहमति से प्रकरण को विचारण नहीं करना चाहते, इस कारण प्रकरण का विचारण नहीं चाहते हैं, इसलिए निराकरण कराना चाहते हैं। अतः माननीय न्यायालय से प्रार्थना है कि प्रकरण का आपसी सहमति के आधार पर लोक अदालत में समाप्त करने की कृपा करें। आवेदक द्वारा अभिभाषक। नहीं सर, इट डज नॉट स्पेसिफाई कि आवेदक क्रमांक 1 की तरफ से था या आवेदक क्रमांक 2 की तरफ से था। इवन इफ my lords assuming for a moment that somebody had authorized him or not, but ये किसकी तरफ से था ये भी क्लियर नहीं है। Now, my lords, I have relied upon some judgment also that if it is not clear, my lords, that on whether applicant number 1 or applicant number 2 authorized him, my lords, then my lords, it is a clear case that there was no authority, and the applicant is the mother.
Please have the judgment, sir. Please enhance the speed of your arguments.
My lordship, I will. My lords, on page number 7 of the my petition, my lords. This is the case of this is AIR 1966 Allahabad, page number 318, and my lords, it says at page number 8, para 4
of your application.
My petition, my lords. Ji.
Raisa Sultana Begum versus Abdul Qadir.
Ji. Thereafter, para 4.
Ji.
There is no distinction between withdrawing a suit and withdrawing from a suit when there is only one plaintiff, and he with the whole suit. It can be said that he withdraws the suit when there are more than one plaintiff and one of them withdraws. It may be better to say that he withdraws from the suit. At common law, a plaintiff has an absolute right to discontinue or dismiss his suit at any stage of proceedings prior to verdict or judgment, and this right has been declared to be substantial. Para 5, it is this right that has been given statutory recognition under Rule 11. The right is not fettered by any conditions. It is an absolute right which a plaintiff can exercise at his own sweet will at any time before the judgment is delivered. In so and so, the court described the right as absolute and capable of being exercised without any permission from the court. Subrule 4 is a provision to Subrule 2 which referred to withdrawal with liberty to file a fresh suit, which withdrawal only requires permission of the court. The plaintiff does not need consent of the defendant or permission or confirmation of the court. In the instant case, the withdrawal was without liberty to file a fresh suit and consequently without leave of consideration, withdrawal with liberty to file a fresh suit. In Hassan Badshah versus Suenso, it was observed that normally a plaintiff has a right to withdraw a suit without reference to the defendant's convenience and without the court permission. Next, it is to be noted that no act is required to be done by the court to complete or effectuate a plaintiff's withdrawal of his suit. There is no provision for any act to be done in the suit by the court for making withdrawal effective, or even after the withdrawal is not, it is not required to pass any order. Withdrawal of a suit itself it's the end. A plaintiff withdrawing his suit is liable for such cost as the court may award, so the court is empowered to pass on an order only in respect of the cost. The liability for cost arises out of the plaintiff withdrawing his suit. The suit has been withdrawn and consequently he becomes liable. The court's order thereafter, my lords, at just a moment, sir.
चलो वो मैं समझ गया हूँ, आप पूरा पढ़ना चाहते तो मैं नहीं रोकूंगा।
नहीं पूरा नहीं पढ़ना चाह रहा सर, मैं पूरा नहीं पढ़ना चाह रहा। जस्ट अ मोमेंट सर। Para 14 onwards, मतलब page number 18.
सर आप उसका जस्ट बता दीजिए।
sir, बता दे रहा हूँ.
आप चिंता मत.
Sir, it only says we have answered the question on the assumption that there is withdrawal in fact as well as in law. The question of referred to us would not arise if there is withdrawal in fact but not in law. My lords, my contention is that I never authorized him to withdraw, and my lords, the withdrawal is not a withdrawal in law. It is only a withdrawal in fact. There had to be a proper authorization, my lords, and the entire claim. I did not receive a single penny of compensation. The entire claim stood withdrawn, my lords. That is my contention, my lord.
16627/2024. Shri Dhruv Verma, counsel for the petitioner through video conferencing. This petition under Article 226 of Constitution of India has been filed seeking the following relief. The office has raised an objection that since this petition has been filed against an order passed by the Lok Adalat, therefore, a writ petition under Article 227 of Constitution of India should have been filed. However, in the light of the judgment passed by Supreme Court in the case of State of Punjab versus so-and-so reported in so-and-so, the office objection is hereby overruled. It is submitted by counsel for the petitioner that the petitioner number one had lost her minor son and in a vehicular accident, and accordingly the petitioners filed a claim petition for grant of compensation to the tune of rupees 1,50,40,000. The petitioners never authorized their counsel to withdraw the claim petition. However, an application dated 11/5/2024 was filed for withdrawal of the claim petition. Not only this application was not signed by the petitioners, but it was not on the authorization by the petitioners, and therefore the application was filed by their counsel, thereby committing a serious professional misconduct. Ultimately, the matter was placed before the Lok Adalat, and by order dated 11/5/2024, passed in MCC number 11/2023 by Lok Adalat number 17, Goharganj District Judge the additional judge to the court of District Judge Goharganj District Raisen. The claim petition filed by the petitioners was dismissed as withdrawn. Challenging the order by which the claim petition was dismissed, it is submitted by counsel for the petitioner that since the counsel for the petitioners have committed a professional misconduct, therefore they have already approached the bar counsel. It is further submitted that even otherwise, it is clear from the application that the counsel, it is not clear from the application that on whose behalf the said application was filed, and there is a distinction between withdrawal of the suit and withdrawal from the suit. Unless and until it was specifically mentioned in the application that both the claimants want to withdraw the claim petition, the traveler the Lok Adalat should not have allowed the application for withdrawal. Consider the submissions made by counsel for the petitioner. The counsel for the petitioner was directed to refer to the complaint made by the petitioner to the bar counsel. The counsel for the petitioner referred to a letter written by the petitioner number one to the president, to the chairman of MP State Bar Council, which was sent by registered mode with a copy to Vijay Khan Soni advocate and JP Chaturvedi advocate. Accordingly, the counsel for the petitioner was directed to address as to whether the said complaint is in the proper format accompanied by adequate court fee or not. Adequate fee or not. It was fairly considered by counsel for the petitioner that the application which has been sent by the petitioner number one is not in proper format and is not accompanied by any fee, any requisite fee. Thus, it is clear that the so-called written complaint sent by the petitioner number one to the chairman of Bar Council is nothing but a camouflage with an intention to give a false impression to the court that the petitioner is aggrieved by the misdeeds of their advocate. The Supreme Court, in the case of R. Krishnan versus Registrar High Court of Madras, reported in 2019, has held that whether an advocate has committed a professional misconduct or not is within the exclusive domain of the Bar Council, be that whatever it may be. The counsel for the petitioner was given an opportunity that he may revive the petition after making a complaint against the counsel to the Bar Council in a proper format. It is submitted by counsel for the petitioner that petitioners are poor persons and personally he is not ready to bear the expense and they will not be in a position to bear the expenses of the second writ petition. And even as a respectable member of the society, he is also not ready to file the second writ petition by bearing a meager amount of rupees 500, approximately rupees 500. He also submitted that he never helps out the litigants on financial side, be that whatever it may be.
And my lord,
Just a minute, Mr. Dhruv, now keep your mouth shut. Don't compel me to use harsh words. Initially, you said that you should be heard. I kept quiet. Don't think that you have any right to interfere during the dictation of the order. Don't cross the limits. You said same thing is मैं तो pro bono करता हूं, मैं किसी के लिए कोई मदद नहीं करता हूं. If you are ashamed of your words, then you should not have spoken. And if you are proud of that, allow me to write it down in the order. Right?
Right, sir.
You should have a courage that whatever is spoken should be written. And if it is written, then you should not feel ashamed of that. Fine. Since therefore it appears that the sole attempt of the petitioners by sending a simple letter to the chairman of MP Bar Council is to give a false impression in the mind of the court that a complaint has been filed to adjudicate whether the counsel for the petitioner have committed a professional misconduct or not. And even the counsel for petitioner is not ready to withdraw this petition with liberty to file afresh after approaching the Bar Council in the proper manner, therefore, the suggestion given by this court for withdrawal of petition with liberty to file afresh was hereby withdrawn. And it was also insisted by counsel for the petitioner that his arguments on merit should be heard. Next, by referring to judgment passed by Allahabad Court reported in AIR 1966, Allahabad 318. Party's name है Shrimati Raisa Sultana Begum and others versus Abdul Qadir and others. It is submitted by counsel for the petitioners that there is a distinction between withdrawal of suit and withdrawal from suit. If there is only one plaintiff, then whether it is a withdrawal of suit or withdrawal from suit will not make any difference. But if there are more than one plaintiff, then the doctrine of withdrawal of suit and doctrine of withdrawal from suit will come into play, and unless and until it was clarified in the application that both the claimants want to withdraw their claim, the claims tribunal should not have allowed the application and should have compelled the counsel should have either rejected the application or should have sought a further explanation from the petitioners or their counsel. Considered the submissions made by counsel for the petitioners. The petitioner number 2 is a minor and she is being represented by her mother as natural guardian. Since the petitioner number 2 is a minor, therefore it is for the petitioner number 1 to act as a guardian on her behalf. Police system. It is not the case of the petitioners that petitioner number 2 was not intending to withdraw. Full stop. Next. The petitioners have also filed the copies of the order sheets of the claims tribunal, according to which it is clear that on 7/2/2024, a statement was made by the counsel for the insurance company that there is a possibility of compromise between the parties and therefore the matter may be referred for arbitration, for mediation. And accordingly, Shri Atul Billore, a judge posted in Goharganj, was appointed as a mediator. On 6/3/24, the case was adjourned as the mediation report was not received. On 23/2024, the case was fixed for framing of issues. And on 3/4/2024, it was observed that the mediation has failed and the mediation report was also received. On 29/4/2024, a submission was made by counsel for one of the defendants that there is a possibility of mutual understanding, mutual settlement, and therefore one opportunity may be granted. And accordingly, the case was fixed for 10/5/2024. On 10/5/2024, at the request of counsel for the parties, the case was placed before Lok Adalat. And on Lok Adalat on 11/5/24 and on 11/5/2024, an application was filed by the petitioners, bracket may, signed by the counsel, the bracket closed, to withdraw the claim petition. Thus, it is clear that the question of compromise was going on for the last more than 2 months. It is not a case that all of a sudden on one fine day an application for withdrawal was filed. There is no averment either in the writ petition or during the course of arguments that why the petitioners did not take any objection to the proceedings which were going on, specifically when the mediation proceedings had already come to an end, had already failed. Well, sister. Accordingly, this court is of considered opinion that the petitioners have failed to make out a prima facie case for interfering with the order passed by order dated 11/5/2024, passed by Lok Adalat in MACC number 11/2023. Full stop. However, this court cannot lose sight of one fact. The petitioner number 1 has lost her son in a vehicular accident, and a claim petition for grant of 1,50,40,000 was filed. Was filed for grant of compensation to the tune of rupees 1,50,40,000. 1,50,40,000. Whether the withdrawal was on account of some out of court compromise or not is a part of the allegation as to whether the counsel for the petitioner has committed any professional misconduct or not, be that whatever it may be. Since the petitioner has leveled personal and serious allegations against the counsels who had appeared before the Lok Adalat, therefore it was necessary for her to implead them as a party, because without giving an opportunity to them, this court cannot record any findings against any of the lawyer. It is well established principle of law that that nobody should be condemned without giving an opportunity of hearing. The Supreme Court in the case of Shivji wala judgment has held that in case if the allegations of malafide are made against a party who has not been impleaded, then the same cannot be considered. Therefore, because of the legal hurdle which has been created by the counsel for the petitioner himself, because it was not expected from the petitioners to guide their counsel about the legal aspects, bracket close. This court is otherwise finding it difficult to adjudicate upon the submissions made by counsel for the petitioners. Under these circumstances, in order to protect the interest of the petitioners, this petition is dismissed with liberty to the petitioner to file a fresh petition after the professional misconduct of their counsel is proved before the Bar Council. It is made clear that in such a, with a force of liberty, the petition is dismissed.
I look at it.
इक्विटीज को संतुलित किया जाए, कितना है सर? तो सर आपका